Usually when we talk about a medical diagnosis, there is this expectation of precision. It feels very engineering based.
Right, it's very binary, broken or not broken.
Exactly. You break your arm, the x-ray shows that jagged white line, and the doctor just points and says, there it is. You know exactly what the next step is.
You put a cast on it.
Right. But then you step into the legal system, specifically the rules that govern how federal lawsuits actually work. And suddenly, that x-ray machine is completely broken.
It is the absolute definition of diagnostic muddy waters.
I mean, you'd think filing a lawsuit is as simple as saying, hey, this person wronged me, make them pay. But it really isn't.
Not at all. The rules of civil procedure are, well, they're a complex, interlocking web of strategies. There are unforgiving deadlines and highly specific exceptions.
And for you, our listener, whether you are prepping for the multi-state bar exam, the MBE, or you're an ESL student just trying to untangle this dense English legal terminology, it can be totally overwhelming.
Oh, absolutely. Because a single misstep, like missing a deadline by one day, can completely destroy a perfectly valid lawsuit.
And that is our mission for today's deep dive. We are taking the federal rules of civil procedure regarding pleadings and motions, and we are translating them into plain, simple English.
We're going to break down the timeline of a lawsuit, starting from the moment it is born, moving to how the defense fights back.
And, how parties can change their stories, and finally, how the court punishes people for lying. We are focusing heavily on the high-yield concepts for the MBE.
It's a fascinating journey, honestly, because every single rule we will discuss exists for a very specific historical reason. They aren't just arbitrary hoops.
Right. So let's look at the starting line. When you want to sue someone in federal court, you have to file a document called a complaint.
Yes, the complaint is the foundational document.
But a massive question comes up right away. How much detail do you actually have to put in that initial document? I'm imagining like a 500-page novel.
Well, no. Federal courts use a standard called notice pleading.
Notice pleading. Let's keep the English very simple here. What does that mean?
In simple terms, notice pleading just means giving the other side a heads up. You are telling them what they're being sued for.
So I don't need to detail every single tiny fact.
Exactly. You don't need to lay out your entire legal theory with absolute perfection. You simply must give the defendant fair notice of your claims.
Okay, let's unpack this. It's like inviting someone to a business meeting.
I like that analogy.
Yeah, you don't hand them the exact word-for-word transcript of what you will say at the meeting, but you do tell them the date, the time, and the general topic.
Right, like first quarter budget review.
Exactly, just so they can open their own files, prepare, and not be totally blindsided when they walk into the room.
That is a highly accurate way to visualize it. You give them context. But, to truly understand where we are today, we have to look at where we came from.
The history.
Yeah. What's fascinating here is that historically, the bar for notice pleading was incredibly low. In 1957, there was this landmark Supreme Court case called Conley v. Gibson.
Okay, Conley. What happened there?
It involved African-American railroad workers suing their union for discrimination. And the Supreme Court established a rule that became law for 50 years.
50 years is a long time. What was the rule?
The Conley standard said a complaint would only be dismissed if it appeared beyond a doubt that the plaintiff could prove no set of facts to win.
Wait, no set of facts. That phrase sounds so extreme.
It was extreme.
That means, as long as there is some microscopic, wild possibility that I could win, the judge has to let my case move forward.
Precisely. Unless your complaint was complete nonsense, you got to proceed to the next phase, which is called discovery.
And discovery is the part where you get to demand documents and emails from the defendant, right?
Exactly. But I'm sure you can see the massive problem with that.
Yeah, I mean, if any possible case gets through, wouldn't lawyers just file incredibly vague, weak lawsuits, just hoping to stumble upon evidence later?
That is exactly what happened. As we moved into the modern corporate era, the discovery process became catastrophically expensive.
Because of computers, right? Millions of emails.
Right. Terabytes of data. Allowing any vaguely possible case to go forward was devastating for defendants. They had to pay millions just to dig through emails for weak cases.
So the system was basically drowning. How did they fix it?
In two very famous Supreme Court cases. For anyone taking the MBE, you must have these burned into your memory. The first was Twombly in 2007.
Okay, Twombly. Let's break that down.
It was an antitrust case. Consumers sued big telecom companies, alleging they formed an illegal conspiracy to keep prices high.
But wait, just because two companies do the same thing, like keeping prices similar, doesn't automatically mean they illegally conspired in a smoky room, right?
Exactly. It could just be normal, independent business decisions. The consumers didn't have actual proof of a conspiracy.
They just saw the behavior and said, it's possible they conspired.
Right. And under the old 1957 Conley rule, that might have been enough to force the telecom companies to hand over millions of emails.
But the Supreme Court stepped in.
Yes. They said the cost of antitrust discovery is too astronomically high. They declared a complaint needs more than just a possible claim. It needs facts that make the allegations plausible.
Okay, let's pause here. For our ESL listeners, let's translate those two words, possible and plausible, because they found almost identical.
They do. But in a courtroom, they are worlds apart.
Right. Possible means the chance of it happening is greater than 0. Like, it is technically possible that my neighbor trained a flock of pigeons to steal my mail.
That would be impressive, but yes, it's possible.
But plausible means it is believable based on human common sense. It makes logical sense.
That is the exact distinction. If a claim is merely speculative, it gets thrown out.
So that was Twombly. But you mentioned 2 cases.
Yes. Twombly was an antitrust case.
Yeah.
People wondered if this strict plausibility rule applied to everyday lawsuits, like car crashes.
And did it?
That question was answered 2 years later, in 2009, with Ashcroft v. Iqbal. And the facts here are incredibly heavy.
What happened in Iqbal?
Javed Iqbal was a Pakistani Muslim man arrested in the U.S. after the September 11th attacks. He claimed he was subjected to harsh confinement based entirely on his race and religion.
That's awful.
Yes. And he didn't just sue the prison guards. He sued John Ashcroft, the Attorney General, and Robert Mueller, the director of the FBI.
He alleged the top officials directly ordered the discrimination.
Exactly. And the Supreme Court looked at that complaint and asked the new magic question, is this plausible?
And what did they say?
They concluded it was not plausible. They said the more common sense explanation was that Ashcroft and Mueller were implementing a sweeping policy to arrest suspected terrorists, not directing guards to abuse specific detainees out of pure racial malice.
Wow. So because he didn't have specific facts showing that top-level intent, his case against them was dismissed.
Yes, and more importantly, the court announced that the Twombly plausibility standard applies to all federal civil cases, period.
Okay, let me do a quick recap for the listener. A plaintiff writes their complaint. They hand it to the judge. The judge now acts as a gatekeeper.
Correct.
The judge reads it and uses common sense to ask, is this plausible? And if it's just wild speculation, the judge throws it out before the defendant spends a dime on discovery.
That is the modern reality of federal court. They raise the drawbridge to stop frivolous lawsuits.
Okay, so we know we need a plausible story. But how do we actually start the stopwatch? Because in the legal world, missing a deadline by 1 day is fatal.
Deadlines are the lifeblood of civil procedure. Let's start with Rule 3. A civil action officially commences, meaning it legally begins, by filing a complaint with the court clerk.
So the moment the clerk stamps the paper, the lawsuit is born.
Exactly. But there is a massive curveball here regarding the statute of limitations.
Let's define that simply. A statute of limitations is an expiration date on your right to sue. If you have 3 years to sue and you file 3 years and 1 minute later, you lose.
Perfectly said. Now, the curveball is a case called Walker v. Armco Steel Corp. It says that in a federal diversity action, state law decides when an action commences.
Wait, okay, first, what is a diversity action?
A diversity action is a specific type of case. Normally, federal courts only hear cases about federal laws, but they can hear cases involving regular state laws, like a car crash, if the parties are from different states.
Ah, so a New York plaintiff suing a California defendant over an Ohio car crash, because they are from different states, there is diversity.
Right, they go to federal court to get a neutral referee.
But why does state law get to decide when the lawsuit officially starts? We are in a federal building.
Because of a fear of forum shopping. Imagine New York state law says a lawsuit doesn't start until the defendant is physically handed the papers.
Okay.
But the federal rule says it starts the second you hand paperwork to the clerk.
I see the game. If my deadline expires tonight at midnight, I don't have time to find the defendant physically, so I just run to the federal court and file with the clerk to save my case.
Precisely. You shop for the federal forum just to get a longer time to sue.
Yeah.
The Supreme Court hates that. So in Walker, they said no.
If you are only in federal court because of diversity, you have to use the state's rules for when the clock stops.
Exactly. For the MBE, remember that trap. Don't blindly apply the federal commencement rule if it's a diversity question.
Such a good tip. Okay, so we've stopped the statute of limitations, but a lawsuit triggers dozens of other tiny deadlines. You have 21 days for this, 14 days for that.
Right. Rule 6A1 governs time computation, and people mess this up constantly.
How do we do the math?
The fundamental rule is the day zero rule. The day the triggering event happens does not count.
Let's run a hypothetical. Let's say I am served with a lawsuit. A person physically hands me the papers on a Tuesday. I have 21 days to respond. How do I count?
Tuesday is day zero. You do not count Tuesday. Wednesday is day one. Thursday is day two. And you count every single day, including weekends and holidays.
So day 21 lands exactly 3 weeks later on a Tuesday.
Correct. But here is the critical exception. What if you have a 14-day deadline and the triggering event happens on a Sunday?
Sunday is day 0. Monday is day 1. 14 days later is a Sunday.
Right. And the rule says if the last day is a weekend or holiday, the deadline rolls over to the next business day.
Wait, if my 14th day is Sunday, I don't lose a day, I actually gain one.
You gain a day. It rolls over to Monday. The logic is pure fairness. Historically, courts were closed on Sundays. You couldn't physically file papers.
But let me push back on that. Today we use electronic e-filing. The server is awake 24/7. Why do I get a free pass on Sunday if I can just click upload from my laptop?
It's a great question. But technology fails. Servers undergo maintenance on weekends. If the system crashes on Sunday night, there's no IT help desk open.
Ah, that makes sense.
Also, they don't want to force law firm staff to work weekends to troubleshoot filings, so the rollover rule remains.
Okay, there's another quirky math rule. Rule 6D, the 3-day rule.
Yes. If you are responding to a document sent by mail or left with a clerk or sent electronically, you get 3 extra days added to your deadline.
I get the mail part. It takes days for a mail truck to travel. But why do I get 3 extra days for an email? It arrives instantly.
Historically, they added it for electronic service to encourage lawyers to agree to e-filing without feeling penalized. But be careful. The rules around electronic service are constantly evolving. Always check the current version of Rule 6.
Got it. Okay, let's recap our timeline. We are in federal court. We have a plausible story. We know how to count our days using day 0.
Yes.
Now, what exactly goes into that initial document, the complaint? Rule 8A gives us the recipe. What are the ingredients?
3 non-negotiable elements. First, a short and plain statement of subject matter jurisdiction.
Okay.
Second, a short and plain statement of the claim. And third, a demand for relief.
Let's break those 3 down like a simple shopping list. Imagine going to a massive department store to return a broken TV.
I'm tracking.
The first part, jurisdiction, is you telling the security guard at the door, why am I in this specific store? You have to prove you bought the TV here. In court, you prove why the federal judge has power over the case.
Perfect.
The second part, the claim, is you taking the TV to the clerk and saying, here is what is broken. This is your plausible story of what the defendant did wrong.
Exactly.
And the third part, the demand, is you saying, I want a cash refund. In court, this is your demand for money damages.
That is a very helpful way to compartmentalize it. But here's something fascinating about the second ingredient, the claim.
What's that?
Under Rule 8, you are legally allowed to plead alternative claims that flatly contradict each other.
Wait, really? The rules say I can make contradictory claims. Isn't that like saying I didn't steal the car, but if I did, the brakes were already broken?
It sounds totally absurd, I know.
Oh.
Almost like perjury. But there's a pragmatic reason for it.
Why would the law allow that?
Think about the timeline. The complaint is filed at the absolute beginning, before discovery. The plaintiff doesn't know all the facts yet. The defendant holds all the internal secrets.
Ah, so plaintiffs might not know exactly what happened, so they are allowed to cast a wide net.
Precisely. You cover all your bases early on. Later, when you finally get the defendant's emails, the contradictory claims will naturally narrow down to the true legal theory.
Okay, so Rule 8 gives us this very forgiving, plain, wide net recipe, but there is an exception. Rule 9, special matters.
Yes, sometimes short and plain is not good enough. Sometimes you must be excruciatingly specific. The biggest example for the MBE is fraud.
Fraud. Rule 9 says you must state fraud with particularity. What does that mean for an ESL learner?
Particularity means great detail. You must detail the who, what, when, where, and how.
So I can't just say, the defendant tricked me.
No, you must say, on Tuesday at 2 p.m., Mr. Smith handed me a forged financial document titled Q3 Earnings, knowing it was fake, to make me buy stock.
Why does the law make it so hard to sue for fraud?
If we connect this to the bigger picture, Fraud is a very serious accusation. It implies deceit and malice. Just filing the document can ruin a person's reputation.
So the rules make you show your evidence up front to stop lawyers from using the word to extort settlements.
Exactly. But here is the nuance. While you must detail the circumstances of the fraud, the mental state of the defendant, like their intent, can be stated generally.
Why the split?
Because you cannot look inside someone's head. You can't prove their secret thoughts before discovery. So you describe the forged document in detail, but you can just generally say, he knew it was fake.
That's a smart balance. There's another Rule 9 exception, right? Special damages.
Yes, special damages are financial losses that don't predictably flow from the event.
Give me an example.
If you were in a car crash, predictable damages are medical bills. But what if you were driving to an auction to sell a painting for $1 million and the crash made you miss it?
The defendant backing out of their driveway couldn't possibly predict that.
Exactly. Because it's so unusual, you must specifically list it in your complaint so the defendant isn't unfairly surprised.
Okay, let's do a slow recap. The plaintiff filed the complaint, they proved jurisdiction, stated a plausible claim, demanded money, they detailed any fraud. Now, they hand the papers to the defendant.
Right. We are switching sides. We are looking at the defense's shield.
How does the defendant fight back before even filing a formal answer?
With Rule 12b, motions to dismiss, this is the defendant telling the judge, before we argue about the facts, there is a fundamental legal flaw here.
Let's list these quickly. Number 1, lack of subject matter jurisdiction. Number 2, lack of personal jurisdiction. What's the difference?
Subject matter is the court's power over the type of case. Personal jurisdiction is the court's power over the specific person. You can't sue a Texas company in Maine if they do no business in Maine.
Got it. Number 3, improper venue. That's just the wrong physical courthouse, right?
Yes, geographic inconvenience.
Numbers 4 and 5 are insufficient process and insufficient service of process.
Process is the paper itself. Maybe it's missing a seal. Service is the delivery. Maybe the server threw it in a storm drain instead of handing it to you.
Okay. Number 6 is the famous 12b6, failure to state a claim.
This tests the Twombly plausibility standard. The judge assumes all your facts are true. If the law still doesn't care, the case is dismissed.
If I sue you for wearing a green shirt, it's dismissed because wearing green isn't illegal.
Exactly.
And number 7 is failure to join a necessary party.
Right, leaving out an essential person.
Here is where it gets really interesting for the exam. The concept of waiver. For our ESL listeners, waived means you lost your chance to use it.
Yes. The omnibus motion rule says you must consolidate your defenses. 4 of them are strictly use it or lose it.
I'm going to list them slowly. Personal jurisdiction, improper venue, process, and service of process.
If you file a motion and forget to include those 4, they vanish forever.
Let's use an analogy. It's like complaining about your seat at a stadium.
A baseball stadium's perfect for this.
Yeah, you sit down and your seat is broken. If you complain to the usher in the first inning, they move you. That's like personal jurisdiction or venue.
Right.
But if you sit in the broken seat for the whole game, you can't ask for a refund at the end. You waived your right by staying silent.
That perfectly illustrates waiver.
Sure.
But let's contrast that with subject matter jurisdiction.
That's the ultimate trump card, right?
Yes. It is never waived. Using your analogy, it's not a broken seat. It's walking into the stadium and realizing they are playing baseball on a basketball court.
It's fundamentally wrong.
Exactly. The court has zero constitutional power. So you can point that out at any time, even years later on appeal.
What about the 12b6 failure to state a claim?
It's a middle ground. You can raise it any time up to trial, but not after.
Okay, let's move on. The defendant's motions fail. Now they must formally respond. This is called the answer.
Yes. You have 21 days after being served, or 14 days after your motion is denied, to file the answer.
And what do you do in the answer?
You go paragraph by paragraph through the complaint. You must admit, deny, or state that you lack sufficient knowledge.
If I genuinely don't know, saying I don't know counts as a denial, right?
Yes, but you must do a reasonable investigation first. You can't just be lazy.
What if I genuinely don't have enough time to investigate every single claim in 21 days?
As long as you made a good faith effort to check your records, pleading insufficient knowledge is okay.
But here is the danger. What if I accidentally skip a paragraph?
If you fail to deny an allegation, it counts as an admission.
Wow. In normal life, ignoring someone might make them go away. But in federal court, ignoring an accusation means you agree with it.
It's terrifying. Silence equals agreement except for damage amounts. You must be meticulous.
The answer also includes affirmative defenses. Let's define that simply.
It means, yes, I did it, but mutee here is a legal reason I shouldn't have to pay.
Like, yes, I crashed the car, but the statute of limitations expired.
Exactly. And Rule 8c says you must state these in the answer, or they are waived.
Use it or lose it. Okay, moving along. Lawsuits are messy. What if we need to change our original story?
Rule 15 governs amendments. You get to amend your pleading once as a matter of right within 21 days, a free do-over.
And if I miss the 21 days?
You ask the judge, and the rule says leave is freely given unless it causes prejudice or is futile.
But here is the massive exam topic, Rule 15c, the relation back doctrine.
Yes, the legal time machine.
Let's set the stage. The statute of limitations, the expiration date has passed, but I discover new evidence and want to amend my complaint to add a new legal claim.
Normally, you'd be too late, but relation back asks, why let someone time travel? Because of fair notice.
Right. If the new claim arises out of the exact same event, like a same car crash, the defendant isn't surprised.
Exactly. They already knew they were being sued over that crash, so the court pretends your new amendment was filed on the original date.
That's for adding a new claim. But what if I want to use the time machine to add a brand new party, a new defendant?
That is heavily tested. It relates back only if it's the same occurrence, the new party got notice within 90 days, and they knew they were the right target, but for a mistaken identity.
Mistaken identity. Let's use an analogy. It's like correcting a typo on a package delivery.
Go on.
I order something online, but type my name as John Smith instead of John Smythe. The box arrives at my house. I see it on my porch.
Right.
I know I ordered it. I know it's for me. The sender just made a typo. I can't pretend I didn't get it.
That is a perfect illustration. In the corporate world, a plaintiff might sue Target Corporation right before the deadline.
Yeah.
Instead, the actual owner, Target Brands LLC. After the deadline, the plaintiff fixes the typo. Does it relate back? Yes. Same slip and fall, the corporate lawyers had notice within 90 days, and Target Brands LLC knew it was a mistake of identity.
We saw the package on the porch.
Exactly. But if you try to add a random local mechanic a year later, he had no notice. That's a lack of knowledge, not a mistake of identity.
Yeah.
The time machine fails.
Excellent. Let's do a thorough, slow recap. We covered the 21-day right to amend and the magic of the relation back time machine for claims and parties.
It's all about fair notice.
Okay, we are in the home stretch. We've given parties a lot of power to file claims, deny things, and change their minds.
We have.
How does the court stop lawyers from lying or playing dirty tricks?
Rule 11 sanctions.
Let's define sanctions simply. Penalties or fines for breaking the rules.
Right, and it starts with a signature. Every paper must be signed. By signing, you certify that after reasonable inquiry, the document is not for an improper purpose.
No harassing people.
Exactly. You certify the law supports it, and the facts have evidentiary support.
So if I file a fake car crash claim just to extort a settlement, I violated Rule 11.
Massively. And the judge can sanction you. But the philosophy is key. Sanctions are meant to deter, not to punish or compensate.
Slap on the wrist to say never do this again rather than bankrupting the lawyer.
Exactly. And law firms are jointly responsible for their lawyers.
So what does this all mean in practice? How do sanctions start?
This is the safe harbor rule.
Yeah.
If you catch me lying, you draft a motion for sanctions. But you can't give it to the judge yet.
Right. I serve it to you first, and I have to wait 21 days.
Yes. It's a mandatory 21-day window for me to withdraw the bad document without penalty.
It's a take-back-see, a warning shot.
Right.
But wait, doesn't that just let liars game the system? They file a lie, see if they get caught, and if they do, they just withdraw it.
People criticize it for that.
Yeah.
But federal judges are overwhelmed. They don't want to deal with minor lawyer squabbles. The safe harbor forces lawyers to police themselves.
It cleans up the docket without bothering the judge.
Exactly.
What if the judge catches the lie on their own initiative, sua sponte?
The judge issues a show cause order, no safe harbor. But the court cannot issue monetary sanctions on its own if it happens after the parties settle the case.
Wait, if the court catches you lying, it can't fine you if you settle the case first? Why protect a liar?
Because the system's highest priority is resolving disputes. If lawyers feared surprise fines after a settlement, they would never settle. They'd drag cases out.
Wow. They protect the settlement above all else.
Yes, it's a grand balancing act.
Okay, let's bring it all together. We made it through the maze. We filed a plausible story. We counted our days using day zero. We used our defenses before we lost them. We answered honestly, amended when needed, and acted in good faith under Rule 11.
It is a massive amount of machinery. But they balance a plaintiff's right to justice against a defendant's right not to be dragged through a meritless nightmare.
And I want to leave the listener with a philosophical seed. We talked about a human judge deciding if a complaint is plausible under Twombly and Iqbal.
We did.
As society moves toward AI and instant digital communication, how might these rules evolve in the next 50 years? Could an algorithm determine if a complaint is plausible before a human judge reads it?
It's a profound thought.
Yeah.
How does a machine understand human malice or complex fraud?
It's exactly something to mull over. For our listener, especially if you are working on your English and your legal reasoning, keep practicing, keep visualizing these concepts.
You can master this. Just take it step by step.
Thank you so much for joining us on this deep dive. Keep diving deep, and we will catch you next time.